Good afternoon, everyone. Welcome to the third lecture of N100 series, in which we are discussing complete polity from mains perspective. We are going to take up various themes on which a UPSC question is expected in mains exam. We are going to discuss it from the various dimensions in which a question can be asked. We would also go into the detail what are the points that should be written if a question is asked, what's the reason, context, background, everything. The only thing we will keep in mind that I shall assume that you have the basic knowledge of polity. So in case you have already studied polity from any place, even if you have understood a little bit of knowledge, this class is going to be very useful for you to develop the depth of understanding in polity. Okay, so I welcome you all to this lecture. My name is Madhusudan Sarma. I am a graduate of IIT Kharagpur and an ex-officer of NABARD, Government of India. So let's start this class. Before proceeding further, those who are live, those who are joining live, I would say that you must sit with pen and paper. You must take a note of the things that I am going to teach you in the class, because unless or until you make a note of it, you may not be able to revise it in the future. And if you do not revise something, when 1 year later you are going to write the mains paper, you may not be able to write all the points that we studied in the class. Okay. You guys, welcome to the class. I hope audio and video everything is clear. Okay. If you have any issue, okay, thank you, Nagendra. You have pen and paper ready, and also you must keep your fingers ready on the keyboard. As and when I ask any question, you must give answer to that as well. We will try to keep this session engaging. Okay, so in last class, we have studied about reservation. We had started, we have already discussed what are the arguments in favor of reservation, what are the arguments against reservation. From moving further from the same point on the reservation, there is also this issue which was there because of the EWS reservation. Okay, so as you must be knowing that EWS reservation has been introduced in our constitution through a constitution amendment. Can you tell me the number? Which constitution amendment introduced EWS reservation in our constitution? I will tell you the article number. It is article number 15(6) and 16(6). So article number 15 and 16 were amended by 103rd Constitution Amendment Act. So through this Constitution Amendment Act, our constitution was amended to provide for reservation on the basis of economic criteria, economically weaker section. They were provided reservation. That reservation is 10% of the total seats in both education institution as well as government jobs. Okay. Now the issue of these factual things may not be asked in the exam. What can be asked is that what were the issues that were raised, why this was considered unconstitutional. People went to the court, and then Supreme Court has already given its ruling that it is not unconstitutional. So what was the reason given by the Supreme Court when it declared this reservation as constitutional? Okay, so this amendment was brought in 2019. The Supreme Court gave its ruling in 2022. Okay. So the argument which was given in Supreme Court first was that reservation is allowed on social and educational backwardness criteria. Like earlier also you must have seen in the Indira Sawhney case as well, the same was discussed that reservation can only be given for social and educational backwardness. In fact, in Indira Sawhney judgment, in this Indira Sawhney case, Supreme Court has declared 10% reservation to economically weaker section as unconstitutional. So people again raised to the Supreme Court and said that, see, you have yourself given a judgment in Indira Sawhney case, and you have yourself said the social and educational backwardness is the only criteria which is allowed as per the constitution. So, and why social and educational backwardness? Because this has historical background. So social and educational backwardness is because of our society, the way caste system is rooted in our society. This has historical nature, and because of that, since constitution only allows this, people said that it is a violation of basic structure. Now why this basic structure argument was given? Because here it is a constitutional amendment. Okay, and any constitutional amendment can only be declared null and void if it violates the basic structure. So though the petitioner had to prove in the Supreme Court that this amendment was violating the basic structure of constitution, so they said that reservation on the basis of social and educational backwardness is part of basic structure. Why? Because this is something which comes from right to equality, and right to equality is part of basic structure as declared by Supreme Court. Okay, are you getting it? So their argument is that right to equality is basic structure. Right to equality says that reservation can only be given for social and educational backwardness. So when you are giving some other criteria, you are violating the basic structure. Further, this reservation was saying that it would not be given to scheduled caste, scheduled tribe and OBC. This was also declared by the petitioner, or rather not declared. Uh, the petitioner sought to declare it unconstitutional because they felt it is discriminatory, that you are giving reservation to those people who are from general category but they are economically weaker. But what about those people who are belonging to SC, ST and OBC but they are also economically weaker? So they said that this is discrimination against SC, ST and OBC. Okay. Then it also violates the 50% cap on reservation, because now reservation is extending to 60%, and this 50% cap, when Indra Sahni's judgment, the same judgment has given this 50% cap, it was considered, or like people argued that a balance between merit and social justice, a balance between merit and social justice is cornerstone of our constitution. A balance has to be maintained between the two. Since this balance is being violated when we are increasing it to 60%, we are violating the constitution. And it was also said that when we are, the Article 14 Supreme Court has given the ruling that any classification has to be a reasonable classification. And this classification that you are trying to give is not a reasonable classification. So that's why it was considered violative of right to equality. Is it clear? What were the argument, the challenge, the argument of those people who were challenging this constitution amendment? We need to understand both sides. Again, we will counter all these arguments, that these arguments are not valid, or rather Supreme Court did not consider them a valid argument. But again, we must know first what were the arguments. Then only we can understand what were the counter argument of Supreme Court. Is it clear? Okay. So now let's see how Supreme Court, what were the counter argument given by Supreme Court in each of these cases. You must note down one after another. Supreme Court said that apart from social and educational backwardness, economic inequality is also a criteria for exclusion. Write it down. Economic inequality is also a source of exclusion. Like in our society, people are excluded from mainstream not only on the basis of caste, religion, or not only on the basis of the gender, but also on the basis of economic inequality. So that's why Supreme Court said that since economic inequality is also a basis for exclusion, that's why this can be a criteria for providing social justice. So Supreme Court did not accept that only social and educational backwardness should be a criteria for providing social justice, since economic inequality is also a reason or other source for social exclusion. This can also be a criteria for providing social justice. Okay, Yogesh is asking this reasonable classification criteria. See, Supreme Court has said that right to equality implicitly includes rule of law. So no classification can be arbitrary, since all the classification has to be reasonable. Okay, so uh, when you are providing reservation, you are classifying people into different category. This classification has to be reasonable. So people were arguing that when you are giving reservation to economically weaker section, this is not reasonable, and this is also not reasonable because now you are expanding beyond 50%. So when Supreme Court in Indira Sahni's judgment has also said that 50% criteria is not only required for maintaining merit, it is also required because if you give reservation beyond 50%, it would become a society based on caste. It would violate right to equality. Okay, so that's why Supreme Court has capped the limit on 50%. So when we breach this limit of 50%, our classification is not going to be reasonable. Okay, is it clear, Yogesh? Next point was that it is violation of basic structure. Here Supreme Court said that through this amendment, only a new criteria for providing affirmative action being added. Listen to it carefully. Whether it is violation of basic structure, he said that through this amendment, only a new criteria for providing social justice or affirmative action is being added. It is not changing the nature of right to equality. Right to equality allows affirmative action. Earlier it was given to socially and educationally backward classes of people. Now an economic criteria is being added. But as such, the nature of right to equality, equality before law or equal protection of law is not being changed. That's why it is not violative of basic structure. I repeat again, through this amendment, only a new criteria for affirmative action is being added. It is not changing the nature of right to equality. So that's why it is not violative of basic structure. It is merely extending the affirmative action to a new group or a different group. It is not creating something, like affirmative action was always there, or neither it is taking away the affirmative action. So as such, the nature of right to equality is as it is. In essence, the essence of right to equality is not being taken away. And in last class also we have seen something, like we have seen in last class that fundamental rights are inviolable but amenable. And I had explained you that inviolable means it cannot be taken away, but it can be amended. Certain modification can be done to those fundamental rights even though they are part of basic structure. But this should not be done so that the nature of our constitution, the basic structure of our constitution changes. Okay, so this Supreme Court said that this amendment is not changing the basic structure of constitution. The third argument, which was like exclusion of SC, ST and OBC is discriminatory, Supreme Court said that it is not discriminatory because these community SC, ST and OBC, they are being provided affirmative action separately. See, their exclusion would have become discriminatory had they not been given any affirmative action or any benefit of reservation. But since they are already being provided reservation, some another group is also being provided. So if something is provided to some other group and also these groups, it cannot be considered a discrimination with this group. Okay, so that's why Supreme Court said that this is not discriminatory. Last point, it violates the 50% cap on reservation. It was simply said that first of all, this 50% cap is not rigid. The judgment itself says that under some exceptional circumstances, this cap can be breached. Okay. The second thing says that this 50% cap was for socially and educationally backward classes of people. So for socially and educationally backward classes of people, the limit of 50% of cap was effective. But when a new category, a new group is being added, this cap, the breaching of this cap is constitutional. And Supreme Court said that the Parliament in its wisdom, this is the part of legislative wisdom, and Parliament is right to enact such changes in its legislative wisdom. That's why Supreme Court considered this amendment, 103rd Constitution Amendment, to be constitutionally valid. I would repeat the last point. In the last point, Supreme Court said two things. First is that this 50% cap is not rigid. The judgment itself said that it can be breached in exceptional circumstances. And the second, that this limit was for socially and educationally backward classes of people. Now that economic backwardness is being added, which is a separate class from the socially and educationally backward classes of people, for them separate reservation can be provided beyond this 50% limit. So through these arguments, we can say that this amendment was not unconstitutional. Is it clear? So now even if a question comes that whether reservation of EEWS category should be there or not, most likely the question will not be there. Question would be in the context of Supreme Court judgment only. But if a question comes, your stand has to be that it is constitutionally valid and it should be there. Something which is in the constitution, something which has been validated by Supreme Court judgment, you should never take any stand contrary to that. Okay. Now we shall move to the second aspect of reservation, which is a relatively latest one. That is limit to reservation. Like in recent time, various state government is trying to push beyond this 50% limit. Okay, for example, Maharashtra is giving 10% quota for Marathas. Bihar has done this socio-economic caste census or survey, whatever they say, and they have tried to increase the quota to 65%. Then like local reservation is also being given. Haryana has also given local reservation. And these reservations have been declared null and void through various high courts and Supreme Court. Okay. So, what is going to be your stand? As I told you earlier, that our stand is going to be in sync with the stand taken by courts. So, since courts have taken with respect to all these reservations a stand that they are not constitutional. So, we have to say the same thing, that EWS reservation is adding a new criteria. But simply extending the reservation which is given to socio and economically backward classes of people, this is not logical. And we will give the same argument which was given by the Supreme Court in Indra Sawhney case. Okay, like it violates the equality clause under Article 14, 15 and 16. So suppose like local reservation, you are providing that 75% of jobs should be given to the local resident or local people from a particular state. You are not treating the people who are outsider on equal basis. And discrimination on the basis of place of residence, place of birth is not allowed. This is discriminatory. their right to equality is violated. Okay, and as I have told you earlier, that in Indira Sahni case, Supreme Court said that exceeding 50% limit would lead to a society not based on equality but on caste rule. Because see, you are reserving the employment or education, all the opportunities on the basis of caste itself. Majority is being decided on the basis of caste, which is not fair, which may not go by the principles of rule of law or right to equality. Okay, so it undermines the principle of equality. And then this is a very good argument. Usually we take this argument in ethics classes. This is a slippery slope. Once, see, as of now there is stability, is there, equilibrium is there, that at 50% we have to stop. If once it is allowed for some state, that some state can have 75%, you may never stop it. Because of the political compulsion, probably you will try to take it to as close to 100 as possible. So again, the whole system would become the what is Supreme Court was fearing, that it would be a society based on caste rule. Okay, so these are the polity related argument. Apart from that, see, based on the context of the question, suppose it is about local reservation, you can give arguments from the economy also. Let's see, companies are also afraid. I mean, they would not have a large talent pool to recruit from. So companies will lose. If the company loses, see why companies? First, companies will not get talent. And if you are not getting talent, there are very few talented people that you have to recruit from that particular locality only. Obviously, the cost will increase. ठीक है? So it will increase the cost of company. And once the cost increases, they become less competitive. So you can say it will reduce the competitiveness of the companies. It will reduce their profitability. You can also show that globally also they will not be able to sell their product or services, goods or services, whatever they are producing. So their profitability would reduce. If profitability of companies are reducing, naturally it would reduce the investment. Those who are investors are not going to be interested in investing in companies which are not going to make profit. So it will reduce investment, and investment is also FDI. So it would reduce FDI. So it has various national ramifications. Then you can take it to various other level as well. So obviously the industries are also not happy with such laws on reservation, and there are chances that ultimately industries will move away from those locality where such reservation policies are being imposed. So this is polity argument. Apart from that, these are economic argument also, because of which our stand is clear that those reservations we do not have to support. Clear? Any doubt? Good afternoon, Satish. Satish name is very interesting. Job Mitra. Satish. Any doubt up to this level? Do you have any counter argument in your mind that you would like to discuss? So, what is going to be final conclusion? What is going to be the way forward? Way forward should be that we should have comprehensive socio-economic survey. We should have first data. That what is the relative standing of different caste group with respect to the social status, with respect to the educational status, also with respect to economic status. Which are the caste group which was really backward, which are the caste group which is forward. Obviously, as the time changes, as different policies are implemented, the relative standing of different groups also keep on changing. So with respect to the updated figure, you should keep on tuning or modifying the reservation policies. Okay, and we should regularly evaluate the outcome of reservation policy, and accordingly we should also regularly update the reservation policy. some caste which have taken adequate which have done adequate improvement in their lifestyle or in their social status, economic status, they should be probably stopped from taking advantage. The other caste should be probably brought into the system of reservation. They should be extended the benefit. Okay, so regular updation of this list should happen. Well, it is easier said than done. Because see, this is like very contradictory. There are few caste group, they are claiming that they are backward. Okay, and they show their strength. They stop the rail, they stop all the public activities. They show their strength, the power, show of power. Okay, and usually if someone is having so much of strength, so much of power to stop all the public activity, to dry the blanket, like destroy the public infrastructure, they are like a strong group. They should not be considered backward. So they are showing their strength to declare, to make government accept the position that they are backward. This is the contradiction which is there in our society. Yes, so this is practically not possible. Once you give something to someone, it cannot be taken away. And see, economically also it was said, earlier there was planning commission. So there was this Montexi Ahluwalia who was the chairman of planning commission. So uh, when this idea was given for the first time, that in the godown of the food FCI, a lot of food grains are getting wasted every year. So why don't we distribute these food grains among the people um, who need it, who are relatively poor? So why don't we distribute it for poor rather for free rather than wasting them? So his argument was, see, we should do it only if we are ready to do it forever. Because once you start giving something for the free, it is very difficult to take it back. Same is with the reservation. Once you have extended reservation to a particular caste group, it is very difficult to roll it back. Okay. Next is it should promote the balanced, rather we should promote the balanced economic growth. The demand of reservation is fueled by the economic crisis in agriculture sector, or rather we call it as agrarian crisis. So our agriculture sector is not growing at a fast pace, and since our agriculture sector is not growing, all those castes who were earlier considered a dominant caste, who were earlier relatively well off because they had land, they were engaged in agriculture activity, they have fallen behind. They are no more prosperous. They are not feeling that they are prosperous. Since they are feeling that they are falling behind the other groups, now they are also demanding that they should be included as a backward caste. So in case we are going to promote the balanced economic growth, if our agriculture sector grows, probably the demand for further reservation will also go down. Okay. Next is, we should have creamy layer criteria, because see, since independence, in one way or another we are implementing affirmative action policies. Okay, even OBC reservation is there for more than 30 years now, and SC/ST reservation is probably more than 70 years old now. So in this time, definitely among these groups also, and even few castes have become relatively well off, and few castes have not been able to improve. And also in the same caste, few families have been able to take advantage, and few other families have not been able to take advantage. So we must exclude the creamy layer from taking benefit of reservation. See, why we are also giving this reason is because Supreme Court has said this in one of its judgments. So now that Supreme Court has said it, we can always quote Supreme Court and say that this judgment of Supreme Court should be implemented. Please explain the Indira Sawhney versus Union of India case. Okay, although I do not expect any question to be asked, so that's why I only explained the ruling given by the Indira Sawhney case, but I would briefly give you the background. See, when OBC reservation was implemented, 27% reservation was implemented, Before that, scheduled caste and scheduled tribe people were already getting reservation. So OBC reservation was brought. People approached the Supreme Court and said that this is unconstitutional. Supreme Court gave the Indira Sahni judgment, and in that Indira Sahni judgment, Supreme Court said that giving reservation to other backward classes is not unconstitutional. They can be given reservation. However, Supreme Court said that there has to be certain uh, basic limits that has to be adhered. One of the limit which was proposed was that the total reservation, or rather the total vertical reservation is when you are adding like, see, if this is the total reservation, first say 15% were reserved for the scheduled caste, 7% were reserved for the scheduled tribe, and then another 27% was reserved for the OBC. So this is the vertical reservation. The Supreme Court has said that total reservation should not extend beyond 50%. And this is the argument which was given by the Supreme Court. Supreme Court has also declared the 10% reservation given to economically weaker section as unconstitutional, because at that point of time Article 15 mentions that some exception, or rather just like Article 15(1) says that no discrimination shall be made. A state shall not discriminate for among the citizens. Okay, and it was said that only socially and educationally backward classes of citizens can be given benefit of affirmative action. So, Supreme Court said that the Constitution does not allow economic criteria for giving any affirmative action. Okay, now this time the thing was different, because this time a constitution amendment was done. Earlier it was not brought through a constitution amendment, that was brought only through a normal legislation. So normal legislation has to abide by the constitution, whereas if a constitution amendment has been done, it has to only abide by the basic structure. If only basic structure is violated, a constitution amendment can be declared unconstitutional, not with the with the prior provision of the constitution. So prior constitution might be saying something else, now constitution is amendment to say something else. So that would not be a criteria for declaring something unconstitutional. Okay, so this is what Indira Sahni case was all about. Is it clear, Satish? Okay. So we are going to also study the Supreme Court, how Supreme Court has allowed, or like the thing that I was saying, that creamy layer criteria should be introduced in all categories, for all categories who are getting reservation. So let's see what was that Supreme Court judgment. The Supreme Court allows sub-classification in SC/ST for quota. What is this judgment? So in this judgment, Supreme Court has said that scheduled caste and scheduled tribe, obviously there are various castes that are included in scheduled caste category. There are various other tribes also which are included in scheduled tribe category. So among those SC and STs, whether they should be treated as one group, or among those also we can have further subdivision, like, see, scheduled caste in total are getting 15% reservation. So can we divide them into, say, two category? One is scheduled caste 1. I am just taking a theoretical example. Another is scheduled caste 2. And we can say that scheduled caste 1, whatever caste comes here, they will get 5% reservation. Scheduled caste 2 will get 10% reservation. This is called sub-classification. Okay. So whether this sub-classification can be done, because some state government wanted to do it, and their rationale is same, that not all the scheduled caste are at the same level. Few have got benefit of reservation and they have become prosperous. They should not be treated on par with other scheduled caste who have yet not got the benefit of reservation. So earlier when the matter went to the Supreme Court read this article 341. So this is 341 is for, this 341 is for scheduled caste. we have the same article for scheduled tribe, that is 342. So 342 have same provision for scheduled tribe. This article 341 says, I will simply summarize you, that president through a notification will declare a list called scheduled caste. Okay, so who will make this list? It would be made by president. Okay, he will prepare a schedule. But any further modification in this can only be done by Parliament. Parliament may by law include or exclude from the list of scheduled caste some category, any caste, race or tribe. Okay. Any change in this list, once president has notified a list of caste as scheduled caste, no change is permissible by a further notification. So Supreme Court interpreted it to say that states do not have any capacity to change the scheduled caste list. Okay, so when you are doing sub classification, when you are saying that one part of scheduled caste is one category, say scheduled caste 1, another is category 2, you are basically tinkering with the list prepared by the president, which is only possible through a law made by parliament. States do not have that power to do that. This is what Supreme Court had taken the earlier position in the judgment E.V. Chinaya versus the state of Andhra Pradesh. In this case, Supreme Court has said that SC and ST are homogeneous group. Homogeneous means there is no distinction within this group. Everyone is scheduled caste and that's all. You cannot say that a part of this group is superior or inferior to other part. Okay. So they should be treated as homogeneous entities, and this is in tune with Article 14 of the Constitution. We have to treat them equal. All those scheduled castes are to be treated equally. So no subclassification is required. But in this Devinder Singh versus the State of Punjab case 2020, this Supreme Court acknowledged that there is intra-category inequalities, and it suggested that this judgment of Supreme Court should be reviewed. So Supreme Court formulated a constitutional bench consisting of 7 judges, because this bench was having 5 judges. So a further bench was constituted that was consisting of 7 judges, and it gave the judgment that sub-classification is allowed. Sub-classification is not unconstitutional. Okay. However, the Supreme Court also said that any such sub-classification must be based on empirical data. So any such sub-classification should be based on empirical data. Empirical data means real data that you collect from the ground. So you should have data that yes, these category of scheduled caste, these castes which are included in scheduled caste, they are something different. You should have data to do this sub-classification. Okay, and the Supreme Court also said that this sub-classification is also subject to judicial review. So in case you do any sub-classification which is arbitrary in nature, which is not logical, it would be considered violation of right to equality. Anything arbitrary is violation of right to equality, and that can be declared null and void. Okay, so Supreme Court applied these two conditions also, that it must have empirical data and such sub-classification is subject to judicial review. Then there is, see, every Supreme Court judgment has two parts. One is action level part, which is to be implemented, and another is non-action level part, which is a kind of advice or analysis of the scenario which is not necessary for the government to implement. And in this non-action level part, the Supreme Court said that the creamy layer criteria should also be introduced for scheduled caste and scheduled tribe, or rather creamy layer exclusion criteria. The Supreme Court argument was very simple. The argument which you must have seen very often on social media, or very often it is being given. Let's see, those people, suppose someone who is a scheduled caste person is already an IAS officer or IPS officer. When their son take any open competitive exam, he sits beside, or rather he competes with the other fellow from his category, and this competition is not fair. This fellow is not on equal footing with a person who is living in a rural area, who is not able to access quality education. So definitely there are few people, few families who are relatively well off among scheduled caste and scheduled tribe also, and they should not be extended the benefit of reservation. But since this is not, this judgment, this part is not in the actionable part of the judgment, this is kind of advisory for the government. It is not mandatory. You must write down in note. It is not mandatory for government to implement it. But if a government decides to implement it, it would not be considered unconstitutional, because Supreme Court has already given its opinion that such exclusion should be done. Such exclusion would be constitutional. So if any government, like central government or any state government, decides to introduce the creamy layer criteria for scheduled caste and scheduled tribe, it would be constitutional. But as per the Supreme Court judgment, it is not binding to implement it. Are you able to do this distinction? Just confirm if you have understood this distinction. And since Supreme Court has given its opinion, Supreme Court has already given its advice, we will take the name of Supreme Court and we will always have this stand that yes, this exclusion should be done. Okay. In my opinion, in your answer, you should write this suggestion. So this is a logical thing, logical suggestion given by the Supreme Court. We should also implement it. Clear? Only in exceptional circumstances, when Supreme Court is blatantly wrong. Okay, this is very unlikely to happen ever. We should go against Supreme Court. Otherwise, always go with the Supreme Court judgment. Never take any stand contrary to the judgment given by Supreme Court. In polity, for us, Supreme Court is like God. Constitution and Supreme Court, these are our two pillars. Next, the last part is what is going to be the benefit out of this judgment. So benefit, we are going to deal with the sub-classification part, okay, because that is the action level part of the judgment. The benefit is very obvious. Would you like to tell something? Any of the benefits when sub-classification is going to happen? How is it going to benefit the society? See, first thing is that now Supreme Court has said that you can do the sub-classification. So if you are sub-classifying it, you will probably focus on those groups which need it more. So it will have a targeted approach of affirmative action. Maybe we can further sub-classify scheduled caste into 5 different groups. So those who are more backward, it will ensure that all section or all caste of the scheduled caste category, they get the benefit of reservation, affirmative action. Okay. Next is the Supreme Court has also said that you should have empirical data to do this sub-classification. So the policies are going to be data driven based on empirical evidences. This is a very good thing. In India, this is the problem. Most of the cases we do not have data, authentic data to make any policy changes. If policy is made on the basis of data, there can nothing be better than this. Then it will enhance social justice, because all those who are, as Yogesh is saying, that those sections who are unlifted, who have hitherto not got the benefit of reservation, they will also get the benefit of reservation. So now the benefit of reservation will reach to even the most backward section of society. Then the state government will now have autonomy, because this sub-classification can be done by the different state government. And now the policy is not going to be uniform. Different state government can have their own policy, their own classification. So first thing is that a state will have autonomy. This is more of a, like, it will boost federalism as well. And the second thing that we are saying is that the policies would also be a state specific. So there is no one size fits all approach. There will be decentralized policy making. And the next is that this may also usher the evolution of reservation system. If we are going to make the changes, probably this is further going to purify the reservation system, further going to make it more robust and more effective. So this is the welcome change that should be adopted at the earliest. Yesterday class, in the end, someone was asking this question, that what should we take the stand on this Supreme Court judgment. Our stand is clear that this should be implemented at the earliest. This is a very good idea and we should go for it. Is it clear? There is no if and but in this. Okay, so that's all that we are going to study with respect to reservation and right to equality. Okay, other other articles etc., they are important from prelims perspective. The questions are usually asked on the basis of the things which are in news. Now the next we are going to study right to freedom. Okay, so right to freedom already, uh, what is the article number? Please tell me for right to freedom. It starts from 19 and goes up to 22. Okay. Article 19 protects 6 different freedom. First is freedom of speech and expression. This is something which remains in news most often. This is something that we discuss very often. Next is freedom to assemble peacefully without arms. Freedom to form association and also cooperative has been added. To move freely throughout the territory of India, to reside in any part of the India, and practice any profession of one's choice. These are the 6 different freedom which is provided by Article 19. Okay, you must memorize all these points. This is very important. As such, directly nothing, a question will not be asked that tell what are those 6 freedom. But see, if you use the exact keyword in your answer, it will definitely look much better than merely writing Article 19 said so. Okay, so that's why I would advise you to memorize these rights. Next is Article 20. It says protection against conviction of offences. Now it has 3 different concepts. First is no ex post facto law. It means that it is for the criminal law. So no criminal law can be given ex post facto effect. Means a law cannot be enacted today which criminalizes something done yesterday. Suppose for any reason, for say it is done that uh, killing someone is made not a crime. Killing someone is not a crime. If it is not a crime today, tomorrow a law cannot be made to punish someone who has done the crime today. Any criminal law can only have effect from today onwards. So whenever a law is enacted, a criminal law will only have futuristic or progressive impact. It cannot have ex post facto effect. Okay. Next is no double jeopardy. You cannot be punished for the same crime twice. So, suppose how it can happen. Suppose a person from say Andhra Pradesh is living in Telangana. Okay, and any crime happens against him. Suppose someone has say beaten him. So one thing that since the crime has happened in Telangana, the Telangana police can register the case against the person who has beaten that person. But now the Andhra Pradesh police can also say that see a person from Andhra Pradesh has been beaten, so we will also punish that person. This is not allowed. So first of all, for any criminal case, you must have seen in the movies also that they decide the jurisdiction, that in whose jurisdiction the crime has been committed, and only that government or that police can penalize the person or court. One person cannot be penalized at two places for the same crime. Okay. Then no self incrimination. A person cannot be made to give evidence against himself. So that's why any statement given in front of the police, like police beat the people, you must have seen that after beating the police, take that person. I mean, when that person accept his crime, like in CID etc., we see that when you accept the crime, the case is over. But in reality, the case is not over there, because even if he accept a crime in police station, police lockup, in court he can say that since police was beating me, I accepted that I have done the crime. Or this acceptance of a person against himself is not admissible in court. One cannot be forced to incriminate against himself. So that's why based on the statement, police goes to those locations where he has said that he has committed the crime, and police recovers those evidences from there, because only those recovery can be admitted in court based on his statement. Can he accept his crime? Yes, in front of court it is assumed that whatever you are saying is out of your own free will. So in front of court you can go and accept that yes, I accept that I have committed this crime. But you cannot be forced to accept a crime, to give evidence against yourself. Like in Arvind Kejriwal case, when police said that see Arvind Kejriwal is not cooperating with the government or with the investigative agencies, so we should be allowed to arrest him. The lawyer of Arvind Kejriwal said that you cannot arrest a person for not giving evidence against himself, because no self incrimination is not allowed. So since self incrimination is a person is protected against self incrimination in a through constitution, you cannot arrest the person for not giving evidence to you. Okay, it's your duty, it's the police duty, it's the prosecution duty to arrange for the evidence. Okay. Next, right to education, we all know. Then protection against arrest and detention. This talk of two different type of detention: punitive detention and preventive detention. Punitive detention, when you have committed a crime, after the crime. And preventive detention is in anticipation of a crime. Suppose you intend to commit a crime, or suppose there is a expectation that something wrong can happen because of your action, then also you may be arrested, although till now you might not have done anything wrong. For example, when article 300 when Article 370 was abolished from Jammu and Kashmir, all the major political leaders of Jammu and Kashmir were house arrested or arrested. Why? This was an example of preventive detention. It was expected that probably next day they might give a speech that can hamper the law and order situation in the state. Okay, so that is an example of preventive detention. See, in briefly only we are discussing. Some other aspect I am going to discuss in detail. Some themes I am going to pick which are of which we expect to be asked in the exam. So first thing is in right to freedom, Article 19(1). What does it say? It says that there is right to freedom of speech and expression. See, UPSC in the past has asked questions about different interpretation of these fundamental rights. And Article 19 and Article 21, these are the two articles which have been most widely interpreted. So that's why these are the two articles on which we are going to focus. Rest of the article, whatever we have just understood, that is going to be sufficient, and likely question is there in prelims, not in mains. Okay, so like right to freedom of speech and expression is by common sense freedom to speak. Like I am currently speaking, I have freedom. Like we can open a YouTube channel and through YouTube channel we can teach or we can broadcast the thing that we want. Okay, then the Supreme Court said that see, if you have to speak something, for that you need to gather information as well. So right to information is also essential part of right to freedom of speech. And then when you are going to speak, you should have freedom to either write. I mean, speak does not mean literally speaking. It should include all the various ways in which one can express itself, like through writing, through phone, through mic, etc., loudspeaker, etc. So all the different ways of expressing oneself is protected under right to freedom of speech and expression. In fact, right to access internet. In Jammu and Kashmir, when internet was banned, people approached the Supreme Court, and Supreme Court said that right to access internet is also part of freedom of speech and expression. So if like I am not getting internet, I cannot express myself through social media. So I have the right to express myself through social media as well. Okay. And from this, we also get the freedom of the press. In India, the freedom of press is not explicitly written. From right to speech and expression, freedom of press is implicitly derived. In USA's constitution, the thing is opposite. Their constitution write freedom of press as the fundamental right, whereas other fundamental rights like freedom of speech and expression of an individual is derived implicitly from this, or rather derived through wider interpretation of this fundamental right. Okay. Next is internet access is a basic fundamental right as said by Supreme Court. Okay. Next, like see, you have freedom to speak. It doesn't mean that you can speak anything. Can you speak something like this? Can you speak something that can hamper the unity and integrity of the country? That can hamper the law and order? Can you defame someone? Can you say anything which is lie? Can you spread lie against other people? Can you spread hate speeches? Can you give us hate speeches that can spread animosity among different communities? That can cause riots, that can cause law and order problem? Can you spread fake news that there is going to be a third world war, or like for those who cannot understand Hindi, this means that third world war has started. So this is completely a fake news, but a lot of media channels are doing this such thing for TRP. So freedom of speech is not absolute. In the last video also, we have already said that freedom of speech or other any fundamental right is not absolute. They can be, yes, you are right, A, E, I, O, U, alphabets, sorry, vowels. So as vowel is confirming, there is going to be reasonable restrictions. So you must memorize the grounds on which reasonable restrictions can be imposed. Not all the grounds I am saying, but at least for 19.1 you must memorize all the grounds. Okay. The grounds are, I mean, a lot many. Sovereignty and integrity of India, security of the state, friendly relation with foreign state, public order, decency or morality, contempt of court, defamation, and incitement to an offense. These are the 8 different grounds on which reasonable restriction, the word reasonable restriction is already there in our constitution. Okay, so on these grounds, the freedom of speech and expression can be curbed. But the list is so long that again, this is the same thing. In the last class also we have studied that our constitution gives right from one hand and takes away from another. Almost every action of everybody can be curbed on these things. And these words are also vague. What is decency and morality? Like it varies from society to society, place to place, from person to person. Someone can consider a premarital relationship as immoral, but someone else can consider it as his freedom, as part of his freedom. Okay, someone can be critical of various religious practices, but someone can consider it as blasphemy. So these are also a bit of vague. The various terms on which restriction has been allowed by our constitution is also vague. And also there is another criticism is that most modern democracies, or rather the constitution of most modern democracies, do not mention the ground for restriction. Like US constitution does not mention that on these grounds your freedom can be restricted. The purpose of constitution is to provide rights, not to limit the rights. Usually in those countries, the limitations, if at all, can be provided is through judicial proceedings. Through various judicial proceedings, the limitations on fundamental rights are provided. Whereas in Indian constitution, these limitations are written. That's also one of the ground. So first thing is that they are too long. The limitation, the list is very long. Second, they are vague. Okay. First is list is too long. Second, they are vague. Third argument is that they should not have been mentioned in constitution. Most of the modern democracy do not mention them in constitution. And fourth argument is that these are framed from point of view of a police. These are framed from the point of view of police, or rather you can say police constable. So you are not looking from the citizen perspective that see what could be, I mean what are the places where citizens may need to exercise their right. You are looking from the police perspective that yes, someone can defame, someone can incite violence, someone can be indecent or immoral, someone can say something that can compromise the public order. So all those grounds you have mentioned in the constitution. This is not in tune with the democracy, rather it is in tune with police state. So these are the criticism which are there. Ultimately, since it is written in our constitution, we got to justify it. that okay, it was right, it should have been there, okay, but we must know both sides of the argument. So these are the criticism which are there for writing these grounds for reasonable restrictions. Okay, now let's see what was Dr. Ambedkar saying when he was met with this criticism. See, he said that in case we have written these grounds for restriction, we are not allowing a scope for interpretation. We are not leaving it up to the courts to interpret on which ground uh, freedom can be restricted. Okay, so not leaving a scope for interpretation. And second is that we are limiting the grounds on which freedom can be restricted. See, suppose it is not mentioned in the constitution as in the case of USA. At different point of time, the different courts can come up with a new ground on which freedom can be restricted, or other government can come up with a new ground which it may be able to justify in the court that this is also a reasonable ground. Our constitution maker said that this will ultimately be restricting our freedom in more ways than possible. So we should have a fixed criteria or fixed number of grounds on which freedom can be restricted. So that's why they considered it apt to include these grounds in constitution itself, that only on these number of limited grounds the freedom can be restricted. Okay, it was not left to the interpretation of the courts or government. Is it clear? Any doubt you may ask. Yes, friendly relation is like any foreign country. If we are having good relation, that is friend relation. So sometimes, like suppose there is a very good example of this. Uh, it is somewhere around 1960s or so, like when China was taking action against Tibet. Definitely a lot many Tibetis people have migrated to India and they were not happy with the action of China. So it so happened that outside the Chinese embassy, or on the wall of the Chinese embassy, few people went there and they pasted the uh, photograph of or rather the poster of the Chinese premier or president over there, and they threw a lot of rotten eggs, tomato, etc. as a matter of protest. So on the wall of the Chinese embassy, they have pasted the uh, photograph of their president, and then they are, and all this happening in India. Like obviously, Chinese government was very angry with the Indian government that you are allowing such activities to happen in India. And at that point of time, Pandit Jawaharlal Nehru said that ours is a democracy and people have freedom of speech and expression. But then you know the long-term result of allowing such freedom of speech and expression, that ultimately India has to go on war with China. Okay, because situation started deteriorating from there onwards. Okay, so if the government of the day decide to curb their freedom of speech and expression, it could have used this ground of maintaining friendly relation with foreign state. Those people could have been restricted from doing those activities, from protesting. Okay, सर डिफेमेशन को डिफाइन किया गया है क्या किसी एक्ट और लॉ में? यस, defamation has been defined, and it has been defined, categorized into two category. One is civil defamation and criminal defamation. Okay, so there is a proper law for defamation, and also for contempt of court also. We have a separate law for that. Next is right to life and personal liberty. This is also this is coming from article 21, and article 21 is one article. Yes, you are right. Rahul Gandhi was sentenced for 2 years of imprisonment. So it's a criminal act as of now. Defamation is a criminal offense. Okay, sorry, it is not civil. That was for contempt of court, civil contempt and criminal contempt. Defamation is a criminal offense. Okay, so as per the law, it is a criminal offense, and the maximum penalty which is there is 2 years of imprisonment. Okay, now let's come back to this. Right to life and personal liberty is under Article 21, and this is one article which have been most widely interpreted by the Supreme Court. And UPSC loves this kind of interpretation in prelims as well as mains. They ask questions very frequently. So let's see Article 21. What does it say? It simply says, and this is something, this wording is directly from our constitution and you must memorize it. No person shall be deprived of his life or personal liberty except according to procedure established by law. Now, in the previous class, I have taught you that few fundamental rights are available to non-citizens as well. See, here the word person has been used. It means this fundamental right is available to non-citizens as well, foreigners as well. And we have seen Article 20 to 28 is available to Indian as well as foreigners. So see, whatever I was teaching you, the proof is available in the bare text. Please tell me yes if you have gone to the constitution or the bare text and read the bare text of all the articles that we discussed in the last class. I told you that this is the habit that you should inculcate. If you did this, please write yes, otherwise write no. Okay, here there is another word which was there. It mentions the procedure established by law. Procedure established by law. And there is another term, that is due process of law. These are the two terms which are very correlated. In our constitution, procedure established by law is written. Procedure established by law means, as the name suggests, that there should be a law. It will definitely prescribe a procedure, and if that procedure is followed, then any person can be deprived of his life or personal liberty. For example, law says that if a court convicts a person of death sentence, then that person can be hanged to death. Then his life can be taken away. So if this procedure is followed, there is a duly constituted court, the court has done the hearing, it has given the judgment, and then the authorized person has hanged that person by death, then it is perfectly okay. Okay. Now, obviously, there is only one condition which is there, that this procedure established by law, the law should be made by a competent legislature. Like suppose the person was hanged for committing corruption because he has taken bribe, and for this a law was made by parliament, and if parliament had the capacity to make such a law, then it's okay. We shall not go into the issue whether hanging someone for taking bribe is a logical thing or not. Whether the law was just, fair and appropriate, this debate we shall not go. Our constitution is simply saying that there has to be a law, and if there has to be a law, it means it should be made by a competent legislature who has the competency to make this law, and it will prescribe a procedure. That procedure should be followed. Then everything is Okay, but there is another concept, due process of law, which says that whatever is there in procedure established by law has to be followed, plus the law has to be fair, just and reasonable. Suppose I am taking a theoretical example, or rather continuing with the same example. If a law prescribes that if you have taken a bribe of any amount, you will be hanged to death. Someone taken a bribe of say 10 rupees, a TT took the bribe of say 100 rupees and gave you a seat, and for that purpose he is hanged. Probably that law would not be considered reasonable. There has to be proportionality in the क्या बोलते हैं the seriousness of the crime and the punishment that is imposed for that crime. For that reason, probably the law itself is not valid. So even if the procedure prescribed in that law is followed, the life and liberty of a person cannot be taken by this law. So if we follow the due process of law, probably the law itself would be null and void. But our constitution usually initially mentioned procedure established by law. Okay. Okay, before moving this, so there was this Maneka Gandhi case. In this Maneka Gandhi case, Supreme Court said that India is a democracy, and in a democracy no law can be arbitrary or unreasonable. So in a democracy, a law has to be, in a democracy, since India is a democracy, a law has to be fair, just and reasonable. So Supreme Court said that there is no difference between procedure established by law and due process of law. So as per Menaka Gandhi judgment, Supreme Court said that procedure established by law has same meaning as due process of law. There is no difference, absolutely no difference between the two. So this is the today's understanding, that although our constitution, I mean verbatim mentions the procedure established by law, practically we follow the due process of law. Is it clear the difference between due process of law and procedure established by law? And also how the rationality, what the rationale that was given by the Supreme Court? Rationale is very important. If you just remember the rationale, you can always frame points in the exam. You can come up with your own innovative points, and that will make a distinctive answer if you have correct understanding of logics given by for various judgment. But if you simply memorize the judgment, you may not be able to write good points. Okay, so try to understand the rationality part. Next is that Supreme Court further said, I am deleting it. I hope you have taken note of it. But the Supreme Court said that right to life does not include mere living. Suppose, I mean, right to life is there with those animals also. But if you are living like an animal, this is not the purpose of our constitution. So, right to life should include right to dignified life. And once Supreme Court said this, now dignified is a word which will include a lot of things. And through this, a lot of different rights have come from right to life. For example, right to privacy. This was declared as fundamental right under right to life. This is a question that has been asked in prelims as well. Right to primary education. Before right to education was enacted in our constitution through 86th amendment, before that Supreme Court has already interpreted that right to life is meaningless if a person is not having education. So a state must provide education. Right to clean, healthy and livable environment. This is something that Supreme Court keeps on telling every now and then. I mean every winter, just from 1 month after this in Delhi, the debate is going to restart. that in Delhi there would again be fog, there would again be like Delhi would be considered as smoke chamber, and all such a statement will happen. A PIL would be filed in the court, and the debate will start. Right to sleep. This is something that Supreme Court gave its judgment when Baba Ramdev and all his followers, they were doing a protest and sitting at Ramlila Maidan in Delhi, and the police kicked them out in the midnight. Okay. Right to leisure. We have a right to take leisure. Okay. You can use this ground as well to say to your parents that we have a right to leisure. Please allow us to sleep. I mean, you have both right to sleep as well as right to leisure. So if your parents say that you should study for 16 hours, 18 hours, you can say that you are violating my fundamental right as protected by the Supreme Court. Then your parents will violate few of your other rights as well. Right to fair and a speedy trial. This is something that was given by Supreme Court in the very first PIL, Hussain Ara Khatun judgment. We will come to that. PIL also we shall study. Then right against cruel punishment. This is also something which is against the dignified life. So that's why like beating someone on the street is not allowed. That is a cruel punishment. You cannot, in India, flogging is not allowed. Only kind of punishment which is allowed in India is incarceration. Okay, and now social service has been added to new constitution, new criminal laws. New criminal laws also we shall study in the tomorrow's class, not tomorrow, like in Monday's class, next class. Okay, so these examples you must memorize, that right to life includes these many different rights as well, and how these arguments have come or how these arguments have evolved. And any new interpretation that comes when you are preparing from today to next 1 year, you must prepare for a question on that. Like a few new interpretation have come. There are two new interpretations which were in use in last 1 year. One is personality right, and second is right against climate justice. So these are the two new interpretations that have come. In today's class, I am going to cover these two interpretations. So I have around 20 minutes more left. I will try to cover these two rights in today's class. Okay, so in these classes, I am also going to cover all the current affair, relevant current affair which have come in last 1 year. Okay. Yes, obviously, Yogesh. I mean, using this right, Supreme Court has often instructed the high courts or the lower courts that you must complete the trial in next 6 months because his fundamental right of a speedy trial is violated. This is another matter. The Supreme Court itself keeps various of the cases for 10 years. Okay, but as such, you have this right. So, like we have all these rights, but whether we are able to access it or implement it or not is a separate matter. Okay, so now let's come to see what is this personality rights. So you must have seen that when you make payment, there are these small machines are kept, QR code, which also speaks, and sometimes it speaks in the voice of Amitabh Bachchan, Devion Sajno. Okay, Dhanyavad, you have done the payment of rupees 10, something like that. The voice of Amitabh Bachchan comes. Isn't there chances that since voice of Amitabh Bachchan, or rather whichever company has done this, they must have kept this in mind that those who are the big fan of Amitabh Bachchan, probably they will do payment more often using that QR code just to listen to the voice of the Amitabh Bachchan. There are a lot many people who love Amitabh Bachchan, or for that matter other film stars. So those companies who are using the voice of Amitabh Bachchan, they are trying to make a commercial benefit out of that. Shouldn't Amitabh Bachchan be paid for this? Definitely. But it is not necessary that we go to Amitabh Bachchan to record this sound. Like, I mean, a lot many people can make sound of some other person. A lot of such mimicry artists are there. So it may happen that Paytm can come up with this idea that yes, Amitabh Bachchan sound, if we say it in Amitabh Bachchan sound, probably people will like it more. But why to go with to Amitabh Bachchan? Amitabh Bachchan will ask for say 10 lakh rupees, 1 crore rupees, or maybe 100 crore rupees, whatever money that comes to his mind. So let's catch a mimicry artist. He will speak in the voice of Amitabh Bachchan. We will record it and then we are good to go. No need to ask Amitabh Bachchan to do the shooting. Or for that matter, for any commercials, rather than having the real Amitabh Bachchan, we can have a mimicry artist who is looking like or look like the Amitabh Bachchan and do the advertisement. This will save crores of rupees that would have gone to Amitabh Bachchan or Virat Kohli or Sachin Tendulkar or any such people. Now, these things are not allowed, or these things, if such activities are done, this is violation of personality rights. So, what is personality right? Personality right is that people have command over their personality. So, any benefit, any commercial benefit out of their personality can only be gained by those people. And this is something that has been implemented, like Delhi High Courts have given this judgment for Anil Kapoor, for Jackie Shroff and also Amitabh Bachchan. The recent one, the latest one is for Jackie Shroff, Bhidu. Okay. I don't know how many of you are aware of Jackie Shroff because he is an actor of last generation, my generation. Okay. So these people, they have gone to the court that their personality rights should be protected. What is personality right? Is that see any characteristic through which you can identify that this is that person. Like there is way they talk, there is way their appearance, their certain dialogues, the way they move around, the way they walk. So any such thing that can be any such personality trait that can lead to identification of that person or through which that person can be identified is part of his personality is protected against commercial use. Write the definition. Any feature easily identified by the public as markers of a celebrity's personality are referred loosely as personality right. It could be name, write it down. It could be name, voice, images, pose, etc. Like no one said that that voice is of Amitabh Bachchan, but we all identified that yes, that voice is of Amitabh Bachchan. Yes, Jackie Shroff is father of Tiger Shroff. This is personality rights. Now, it can be registered as trademark. What does it mean? For example, trademark, what is trademark? Trademark is also a kind of intellectual property. So, trademark is usually used by businesses to register their logo, to protect their logo, so that no one else can use their logo on their product. Okay, so even individuals or celebrities, they can protect certain aspect of their personality, register them as trademarks so that no one else can use it. For example, this person is Usain Bolt and this is his victory sign. He has registered this victory sign, this victory pose rather, as a trademark. So now no one can make any commercial use of this pose, this image, etc. without the consent of Usain Bolt. You have to pay a royalty to Usain Bolt. Now, see, there are one, two other feature as well. The one thing is that this is something a markers of a celebrities. So someone who is famous, only that person enjoy the personality right. So you cannot say that, yeah, I also look like this, I also have a personality right. No, you and me, we are like mortal fellow. Okay, we are lesser mortal. We do not have personality rights. Okay, only celebrities have a personality right that can be identified by the public. Okay, and see, those who are teaching on YouTube, their ultimate agenda is also to be famous so that I could also enjoy the personality right. People could identify my voice. That's our ultimate agenda. As of now, Usain Bolt is enjoying it. Okay. So the idea is that only owner or creator should derive any commercial benefit from these personality traits. Okay. And that person, if someone is taking unauthorized benefit, or other, it should be commercial benefit. So like if Paytm publishes an advertisement, this is also something that is going wrong. A lot many companies are very smartly what they're doing. Like Manu Bhaker has won the medal in Olympic. So they simply published a photograph of Manu Bhaker, published a huge advertisement in the newspaper congratulating Manu Bhaker, and then in the bottom they wrote about, I mean obviously they used their company's logo, etc. This is also considered a violation of the personality right. You cannot use that because ultimately people, this is a kind of advertisement, and for doing advertisement is definitely done for commercial purposes, and commercial benefit you cannot derive from the image of a personality without their due authorization. They can go to the court and seek an injunction. Injunction is prohibitory order that you cannot do these things. They can also ask for compensation if you do it without their authorization. Okay. Next is, we shall see some of the features. How are we deriving? So these are derived from two fundamental rights. One is right to privacy, because right to privacy is based on the premise that you own yourself. You have a right to be left alone. Okay, so whatever belongs to you, your personality is yours. Okay, and also from the right to property. Right to property is also on the feeling that whatever you have earned through your hard work belongs to you. It cannot be taken away without your due consent. And whatever these personality trait, these celebrities have worked hard in their lifetime to gain this popularity, to make their personalities identifiable with the public. So they enjoy this right to property. Okay, and this Trademarks Act and the Copyright Act, these are the IP laws which provides for the trademark and copyright. And these acts are enforced when a person reaches or approaches the court. Okay, as such there is no specific law for protection of personality right. Implicitly through Trademarks Act and Copyright Act it is implemented, but as such these acts does not mention personality right. Okay, and there is this term which is there in news, unauthorized use and fair use. So see, there is always this debate. In the next part also we shall see what are the different challenges in implementation of personality right, but this is always going to be in debate that whether some personalities have their have unlimited power to restrict others from using their personality trait. It should not happen. It is going to create a lot of problems. So it was felt like when you are depicting in news, is it going to be the case that you cannot take photograph of any personality, you cannot depict in the news, I cannot use them in my teaching material to take the example of Amitabh Bachchan? Should I take permission of Amitabh Bachchan if I have to take the example in my teaching material, or other such non-commercial uses? Or like artists which are using mimicry, satire, etc. Someone, a lot many people are uh, earning their livelihood. So it is considered that these are example of fair which should not be protected under personality right, but because this is not merely a reproduction of the personality trait. When I am taking an example of Amitabh Bachchan, I am explaining the whole concept. That is the teaching that I am doing. Amitabh Bachchan is just an example in my teaching. I am not merely directly using Amitabh Bachchan and taking an advantage. Okay, so these are fair use. Whereas if third party makes a profit from it, it cannot be treated as fair use. It is an unauthorized use. So the commercial benefit that we usually take from advertisement, etc., that is an unauthorized use. Fair use is allowed. Okay, is it clear? And last but not least is it can't be inherited. This is something that Madras High Court has ruled. Abhishek Bachchan cannot claim that Amitabh Bachchan personality right is being inherited by me. So once Amitabh Bachchan dies, this right also dies with him. So then anyone can use the voice of Amitabh Bachchan, do the mimicry or any such thing and enjoy all the benefits. But till the time Amitabh Bachchan is alive, no one can do it without the due permission of Amitabh Bachchan. Okay? Now we shall see what are the problems that can come or what are the challenges in implementation of personality rights in India. The first is that this is in conflict with the some provisions of the constitution. For example, it is in conflict with the right to freedom of speech and expression, like those mimicry artists who are using their making their livelihood. Their freedom of speech and expression is also restricted. Okay, it is also with conflict with right to livelihood, which is also a fundamental right, and the right to uh, life. So those artists who are making a livelihood out of these artists or like mimicry, etc., their right to livelihood is also compromised. Then there is a debate between personal data versus public data. So it is said that if you have put any image, photograph, etc. in public life, listen to it very carefully. If you have yourself put any of your personal information, photograph, etc. in public domain, that is not protected in a court of law. That is not protected under right to privacy. You can see, you cannot put a photograph of yourself on Facebook or in public life and then you say that others who are watching this photograph or downloading this photograph are violating your right to privacy. So right to privacy does not extend to those information which you yourself have put in the public domain. Okay, so all these personality traits have been put in public domain willingly by these personalities itself. So this is a gray area, that which of these data to be considered as personal data that is protected and which are to be considered as public data. Okay, and then we have just said, since there is no law, it is always going to be dicey which part is protected, which part is not protected. There is going to be a lot of vagueness, or you can say dispute, debate about the scope of personality right. When we have a law, we know the boundaries of our rights, that we can do this, we cannot do this, and all those. But since there is no law, there is a lot of debate about a scope of the personality rights. Then because of the dark patterns and generative AI, a lot of such content are being generated, which are mimicking, which are like reproducing the acts of the personalities, and it is very difficult to regulate these dark patterns and content made by generative AI. And the next is that since there is no legislative framework, you got to enforce these rights in a court of law. Like Jackie Shroff, Amitabh Bachchan, they have all gone to Delhi High Court to enforce their uh, personality rights. This is a cost and time consuming exercise. So in effect, personality right can also be enjoyed only by personality rights can also be enjoyed by big personalities only. The small personality, these YouTubers, etc., those also who have huge fan following, but they do not have the financial wherewithal to go to the Delhi High Court or any other High Court and enforce their personality rights. So as such, as of now, it is only protected for big personalities, not for small personalities. So those who are on OTT stars or those who are social media stars, their personality rights is as of now not protected in India. So what's your going to be advice? Our advice is going to be that we must frame a law. First of all, bring a law. In that law, address these conflicts. Maintain a balance between freedom of speech, of expression and the personality right. And allow the So what is our advice? First, make a law. In this law, maintain balance. Allow fair use. You should not ban mimicry, etc. You should not ban artists. Okay, it will also curb innovation. You can also write one more point. It will, curb innovation. This is the news which is going on, that since Jackie Shroff has enforced his personality right, now no one can do the mimicry of Jackie Shroff. So if suppose all these famous personality go to the court and enforce their personality right, all these mimicry artists, these singers, etc., who sing the songs of other artists, they will be out of their job. Okay, so it will curb innovation as well. So we should protect them, we should allow fair use, and we should encourage innovation and creativity. And we should also regulate the AI. Yeah, generative AI made content. Okay, so this is what our suggestion is going to be. There should be a law. It should maintain the balance between different contradictions. It should allow the fair use. It should encourage the innovation, and it should regulate the content made by generative AI. Clear? So very quickly, one last thing that I have to teach you, that is right to life with climate justice. Now this is something that Supreme Court has given the judgment in this M.K. Ranjit Singh and others versus Union of India case. Okay, the Supreme Court has simply said that right to life also include right to life against climate change. So right to life against climate change is same as right to life with climate justice. So climate justice is your fundamental right under Article 21. So this is a question that can also be asked in prelims. But here Supreme Court has said that it is not only Article 21 right to life, but also Article 14 that provides for this right. So this is something that you need to understand, how it is saying that Article 14, which is right to equality, is also providing for right to life against climate change. How is it happening? So the argument is very simple. The argument is that climate change is impacting different sections of society differently. And it is usually the weaker section of society which is suffering more due to climate change. Weaker section suffer more due to climate change. Since weaker section is suffering more due to climate change, it is violating the right to equality. So if climate change is happening, the weaker section is getting more poor. I mean, poor people are getting further poorer. Their homes are damaged in a cyclone which is coming. When a flood comes, their home gets washed away. Their livelihood is compromised. Those who are rich, those who are living in Antilla, it doesn't matter whether a cyclone has come or whether a flood has come or anything comes. Okay, but weaker section people, the poor, their livelihood and housing etc are compromised. So that's why climate change is violating right to equality as well as right to life. Right to life is definitely compromised because of these extreme events etc. There is damage to life and property. So right to life is obviously compromised. Okay. So this concept, the implication of this concept is that it integrates social justice, economic development and environmental sustainability. Obviously, if climate change will not happen, there is going to be environmental sustenance. But since it is saying that right to equality is also violated, it is including the part of social justice. So any impact of climate change which is disproportionately affecting different sections of society has to be reversed by the government. Government have to take care of social justice aspect of climate change as well. And obviously economic development. If climate change is affecting the livelihood of any section of society, that also has to be addressed by the government. There is one more related thing. Earlier also Supreme Court has already given that right to life includes protection against or rather right to life includes right to pollution free environment. This is also something which was already said by Supreme Court in MC Mehta case. I mean, under this we have just seen that right to clean environment is there. I have given you the example that when Delhi suffers from pollution, Supreme Court start entertaining PIL, start giving directions to the Delhi government, central government. So what is the new thing in this judgment? Can you make a guess? I will just give you a second or rather give you a minute. What is the new thing or what is the difference? This is right to pollution free environment. This is right to life against climate change. See, the difference is in terms of a scope. Its a scope is broader. Its a scope is narrow. How I am saying that it's broader? Its a scope is climate change. Its a scope is only pollution. See, climate change has much more ramification than pollution. There can be pollution without climate change. There can be climate change without pollution. For example, the people of Lakshadweep can suffer from climate change although they might not have any pollution. Okay? So it is not necessary that you should have pollution for suffering the impact of climate change. Yes, Yogesh, you are right. Okay. So climate change is a global phenomena, whereas pollution is a local phenomena. So whatever the action or ramification that you can sort is at the local level under this right, whereas at this right the ramification that you can sort from the government is going to be global in nature. Okay, and also the time period which is involved, okay, it has a large time span, whereas since pollution is relatively going to be having a smaller time span. Okay, both of them, I mean this climate change aspect, this also includes the impact on biodiversity. Although this also the pollution also Supreme Court has broadly interpreted and included the impact of biodiversity, but only related to pollution. Whereas this impact will also include the impact of other adverse events which may not be related to pollution. So it has, again, the difference is with respect to a scope, and then you can have a scope with respect to time, place and biodiversity. Okay, so that's all that we had to cover in this video. Next class is going to be on Monday, where we are going to study about the rest of the fundamental rights. Okay, I hope you have liked the video. Whatever be your suggestions, feedback, do let me know through comment section. I would love to interact with you people. I would love to reply if you have any doubts. See you again Monday. Goodbye.